Good morning. Today is June 12th, 2025, and this is a public deliberation being convened at 9:30 a.m. by the Baltimore County Board of Appeals. This is case number 24-101-SPH regarding a motion for reconsideration filed by William M. Lagner. Was filed on April 12th, 2025 for property located at 2420 Holly Neck in Baltimore County. The board would like to note that the webinar notice incorrectly stated the case number as 24-202-SPH, and the correct case number is, as I stated, 24-101-SPH. Now, I'm Sharon Bernardi. I'm chairing the hearing today, and I'm joined by my co-panelists and board members, Mr. Fred Lauer and Mr. William Paulshaw. And just very briefly, on October 16, 2024, the panel conducted the hearing. The hearing was held on March 24th, 2025. The panel issued an order denying the approval of an existing lawful non-conforming use for a boarding house on the property as stated, the address as I stated previously. And we amended that order on April 8th, 2025 to allow for previously agreed upon condition that the occupants of the property have 120 days after the date of the order to vacate the property. And so as required by the rules of the board, we are deliberating on this motion for consideration publicly. And that is provided per Rule 12 of the board's rules of practice and procedure. And the reconsideration motion was filed timely within the 30 days after the date of the original order. And it says that the motion shall state with specificity the grounds and reasons for the motion. And just briefly, the petitioner is asking for this motion for reconsideration, stating that there is new evidence that they would be providing if granted the motion. And I just wanted to ask my co-panelists their position regarding the motion for reconsideration, and then I can add any additional comments. And I didn't know who would like to begin. Mr. Lauer, would you like to share your position? I'm sorry, Mr. Lauer, I think you're on mute. I think you're muted. We're not able to hear you.
Sorry, got me?
Yes, we can hear you now. Thank you, sir.
First of all, they're not alleging fraud, mistake, or irregularity here. What they're alleging is that there is new documents / evidence relevant to the case that we should reopen, if you will, and look at these documents and hear these witnesses. Regarding the documents, a couple things. I don't think it was clear. First of all, I thought the memoranda provided by both People's Counsel and the protestants and the petitioners were very good in the case. But it wasn't clear to me how this new evidence was discovered. New evidence is usually something that comes up in between the time that a decision is made and you file an appeal before the court or whatever in this case. So wasn't it clear to me how this new evidence was discovered? Second, it wasn't clear how the tax filings are what was alleged here, or what was proposed that would be presented to us, how they would solve the problem. Third, it's not clear why they weren't available during the public deliberation. There is a public deliberation. There was plenty of time from the time that the ALJ opinion was issued until the board's hearing on the matter. Plenty of time to prepare for this, to put this together. So it wasn't clear, why it wasn't presented at the time. If it was new evidence, these were pretty old tax records, and they had the opportunity to present them at the Board of Appeals hearing. Second, regarding the witnesses, it wasn't mentioned, I don't recall, at the Board of Appeals that witnesses were unavailable. I don't remember that being mentioned at the Board of Appeals. There's no explanation as to why they didn't appear there. So I guess they just said, I believe in the motion to reconsider, they were unavailable, but why? They had plenty of time to set this up. They could have asked for a postponement, a continuance of some sort, if they had relevant witnesses that they thought would have presented or given us additional information, and that wasn't requested at the hearing, nor was it mentioned in my notes anyway from reviewing the record. So basically, I don't see how that we should grant this motion to basically open up the hearing again. And I think one of the memorandum mentioned that this was giving them a second bite at the apple. Having personally presented cases before, I'm sure there were many times where I said, well, maybe I could have presented an additional witness or additional evidence or whatever. But I don't think it was newly discovered. I think the witnesses, as far as I'm concerned, were not mentioned at the hearing, and no explanation why they didn't appear. So my feeling, and subject to, what we're here for a deliberation, and could be convinced the other way, obviously, but pretty strongly believe that we should deny this motion to reconsider. That's where I am.
Thank you, Mr. Lauer. Mr. Paulshock?
Yes, and all the memos were excellent that came in, all three of them. They all held some weight, but the newly discovered evidence is mainly cumulative evidence, and it doesn't get to the core issue. There was said it right in the code itself, that it's a heavy burden of proof. And this evidence was here prior. It could have been presented, could have been postponed. So I feel the same way as Mr. Lauer does. I would have to deny the reconsideration.
Thank you both. And I concur with you for the many reasons stated. As you both said, Rule 12 says that we are to consider the motion, that the motion should state with specificity not just the grounds and reasons, but it includes and not limited to newly discovered evidence, change in law, fraud, mistake, or irregularity. And as you said, I mean, there hasn't been a change in law. There's no mistake, no irregularity, no fraud. And so whether or not there's new evidence, And as you mentioned, don't see that this is new evidence. It was available previously. As you said, all the memos were well-written, but wanted to just take a couple of arguments from, People's Counsel is that this was a de novo case before the board. And so there shouldn't have been any presumption that we would solely rely on what was testified to below. And so the petitioner should have provided evidence from below, as well as any additional evidence that he felt was going to be persuasive for us at the board level. And what he's mentioned in this motion, as you previously stated, like the tax records, that was available, the witnesses, they should have been available. And if they weren't, as you stated, then that should have been said, and they could have made requests for those witnesses to be able to provide some testimony, or even ask for additional hearing aid to bring them forth. But I'm with you. I don't recall any of those arguments being made. And by allowing them to, or if we granted this motion, I do think it would just give them a second bite at the apple and be, a res judicata issue. And I do think it's just additional evidence to help and an argument that they now know was not successful before us. And I believe People's Counsel is the one that they stated a case that said that newly discovered evidence doesn't mean evidence that you wish that you had brought before because you had an unfavorable ruling. And I feel that that's what they're doing here. So I agree with both of you and would also deny the motion for reconsideration. So I think we have a unanimous decision on this motion, and we will get it drafted and issued. And I want to thank you both and thank the parties for following, as we all have said, very thorough motions. And have a good day.
All right, thank you, Madam Chair.
Thank you. All right.
Have a good day, Mr. Lau.
You too.
Thank you.